Good afternoon, everybody, and welcome to the Legal Expertise D&O Claims webinar with special guest attorney Marc Markel of Roberts, Markel, Weinberg, Butler, and Haley. I'm your host, Sherry Branson. Hi, Marc. How you doing?
Doing good. How are you?
Doing well, thank you. Doing well. I know you're in Austin, Texas right now, which is where I'm from. And
Absolutely.
you have a nice view of Austin behind you. So, Marc, you basically live in Texas, and your expertise is, well, you have a lot of expertise, but you work in Texas mainly, correct?
Yes, I represent associations throughout the state of Texas, and we have 5 offices around the state in major metropolitan areas. And basically, I bounce around from one office to the next, and I live in what they refer to as the Texas Hill Country, which is a beautiful place to live, but a drive to any one of my offices or a short flight. So I spend most of the week on the road just helping community associations, and it works out pretty well. I've been doing it for a long time. I think I started in 1979 and started doing defense of D&O claims in the mid-'80s.
Wow. Okay. So you've been in the industry for quite a while. I'm sure you've seen a lot of changes over the years.
Yes, as my hair fell out due to the issues raised by those things, a lot of changes, a lot of legislative changes, a lot of litigation changes, but some things still remain the same as they did from the beginning.
Absolutely. Great. Well, welcome, and thank you for joining us today. And now we're joined by Kevin Davis, the president of Kevin Davis Insurance. Kevin is in Los Angeles. I'm in LA today, so we're still doing a Texas to LA connection. I'm not in Austin, but Marc's in Austin, so.
How you doing this afternoon, Marc?
I'm doing great. How about yourself?
Doing good. Had a nice lunch. It was quick lunch, but it was one I had one.
Yeah, I actually just took a walk for lunch. It was a little bit easier. Downtown Austin today is beautiful. It must be like high 70s, low 80s, no humidity.
Oh, good. Perfect weather.
Gotta enjoy it.
Oh, yeah, absolutely. Great.
And I have to say one thing, Marc, I agree. I've lost a lot of hair, too, over the past number of years doing this business.
I think it should be listed as one of the primary things that's going to happen to you. You're either going to lose your mind or lose your hair. And I guess between the two, I'd rather lose the hair.
I agree.
Good choice. And Kevin, what is our goal in today's webinar? What are we going to talk about today?
Well, this is a good opportunity to really talk about claims from a legal perspective, from a lawyer who handles the claims, not from the company side. And my job is to kind of bring in some coverage examples and how the coverage fits into it. But it's a great opportunity. Marc, I've known Marc for a very long time. We've handled a lot of D&O together, and this should be a really, really exciting webinar today.
Absolutely. We're going to go over some great information. And I did want to mention to everybody that we do put our webinars on our website, on our homepage, which is kdisonline.com. There's a webinar link. You can click on the link, listen to today's webinar, and then all of our past webinars as well. And Kevin, we've been doing them for about 4 years now, I think, a little over 3 years. Yes, we've got
coming up on number 50 pretty soon.
Yeah, that's right. We're heading up to number 50 of our webinars. We've done them on everything across the board, all different topics. And today we've got a great webinar about the legal perspective on D&O claims. And both of you guys have been in the industry for a while, so this will be great. And Kevin, Marc, let's start with you. What is the most important coverage, do you think, in a D&O policy?
Okay, that's a loaded question. And there probably is not one provision that's the most important, but I have a list of things that are extremely important to associations that are only found in the better policies. And those include, probably from the top of the list down, the non-monetary claim aspect. A lot of the policies don't cover those that aren't on the top tier shelf of policies, as well as defense for breach of contract suits, insured versus insured type of issues, and some others. But those are probably the most important to me in terms of a coverage issue, because that defines whether it's a good policy or a not so good policy.
Yeah, and from the coverage point of view, the most important of those coverages are the non-monetary damage claims. Because when you look at a liability policy says they pay damages. When you talk about a non-monetary damage claim, is it because I want to keep my pet and I think the board's incompetent and I'm not suing for money. I just want to keep my little dog. They're not suing for money. They're suing for the right to have something done.
Correct. Or their chicken, or their snake, or whatever it is.
That's
and
right.
sometimes they're suing because they believe that they've been insulted. And what they really want is an apology, or they want to see a document, none of which has any monetary angle to it.
And the coverage that we provide historically has been about that type of, because that claim, if we had this conversation probably 10 years ago, and we probably did, in 20 years ago, it's the same thing that occurred 10, 15, 20, 30 years ago, and it'll probably be the number one claim in the future.
I don't disagree with that. It's not a week that goes by that someone's not upset with their association that rises to the level of a claim or a lawsuit. And I think that's because there's a lot of attorneys out there that are fairly bored, and the community association is an easy target. Most judges don't like community associations. Most people in the street don't like community associations, although they want to live in them, because they want to regulate what their neighbor does, but they don't want to have regulated what they do.
Yeah, so they're emotionally based claims. Would you agree with that? Emotionally based?
Absolutely. One of my friends in Texas out of the Dallas area has coined the phrase that this is the family law of real estate.
It's true.
It's like a divorce case. It really is like a divorce case, huh?
Yeah, absolutely. Yeah, very rarely is about the facts. It's usually about something behind the facts.
Absolutely. Painting the house a certain color, flying a flag, that kind of a thing. And if you had to pick the major reasons why a D&O claim would be denied, what would you say are some of the major reasons that you see?
Okay, the number one reason is that the claim has damages that are related to property loss, property damage claims. And so it may start off as being a claim that we would defend on a D&O policy, and then all of a sudden we get a call saying, well, no, we figured out this is a property loss. It needs to go over the general liability carrier, or it would not be assigned at the front side of it. And the other is there's some personal injury type claims that also have a declaration. But I would say the property damage claim is the number one coverage related issue.
Yeah, and that's the number one for us too that we see. The board's responsibility is to manage the property. And whenever they manage the property and somebody doesn't like what they're doing or what they should be doing, like if the roof is leaking or the fence needs to be repaired or the pool needs to be taken care of, they sue the board for breach of fiduciary duty. The problem is that it's the property damage caused the roof to leak and ruin my pictures and my $100,000 paintings. That's not a D&O claim. It is a general liability claim.
Absolutely. What about late reporting, Kevin? Do you see that as well being an issue?
Well, I would say number two is late reporting of a claim. One of the problems from our point of view is that most people don't realize that the D&O policy is a claims made and reported policy. That means the claim has to be made and reported in that 12-month period. And a lot of times, and you probably see it too, Mark, is where a claim will come into the property management firm. The property management firm, there's that guy again acting up, going crazy, and they'll toss the claim away.
Yeah, and what makes it the absolute worst is not only do they toss it away, but then they change carriers.
Ah, yes.
And we might not even get a year.
Yeah.
Because if we're at the 11th month and we didn't know it was really a claim, or we didn't think it was a claim because he's been complaining for years, and we change carriers because we have to save $116, then what happens is he files the lawsuit the first month into the new policy, and guess what that new policy is going to say to us? Prior act.
Yeah.
We didn't get prior act's coverage, or we didn't report it, we should have known about it, we had something in our file where he threatened to sue us, then we're out of luck again.
Yeah. Sherry, that is a huge issue right now because people, and Mark nailed it, they want to save $100, so they move a D&O. There's a claim out there pending, and they have no idea that once they move that D&O, there is a claims made and reported policy. They believe it's like their auto policy, which is an occurrence policy, they can go back and put a claim, somebody will notice something that happened years ago. That is probably your two biggest areas of claims.
They also think they're like the auto policy and that they're all kind of the same.
Yeah. Right.
It says D&O insurance, so it must be.
Must be, yeah, exactly. Yeah. Absolutely. And I did want to mention that if anybody has any questions about what we go over today, any of the information, we do have a question box on the screen. You can type your questions there, or you can send me an email to sbranson@kdins.com, and we're happy to email you back your answer or give you a phone call and answer your question as well. Great. And now, Mark, what would you say, what are the major coverage concerns with D&O today that you're seeing?
Coverage concerns, it really comes back to the issues that we talked about before, and that is making sure that the policy that the association has covers the things which are the most likely to occur, and it also covers the things that are the most costly to defend if they had to defend them on their own. And so those are those same elements and items again. I just have seen so many policies which don't cover anything, and they put them in a position where you're buying something but you're not really getting anything. Mm-hmm. And so that's an ultimate concern of mine, to make sure that it's not a coverage concern, it's a question that what you have actually does provide you the protection that you need. Kind of like if you were going to go buy car insurance, but it didn't insure you if you were in an accident. You would have car insurance, but it excludes all accident claims. So it's kind of like the D&O policy that excludes non-monetary, breach of contract, insured versus insured, also excludes prior directors, doesn't include committee members, doesn't include the named association, doesn't include the management company. And these are all things that make it still a policy, and it may even be an admitted form policy, but it is not providing coverage that's needed for these community associations.
And it's so interesting there, because that's the reality of the situation, is that most of the package policies out there are so weak that when a claim occurs, I would say the majority of claims that we see will not be covered. The non-monetary damage claims, the breach of contract, the insured versus insured, the things that we see, the arbitrary enforcement of the documents, all those things, the breach of fiduciary duty that leads to the non-money damage situations, they're all excluded under the bulk of the D&O policies out there today.
I took over a community about a year and a half, 2 years ago that was a master community in Texas, and they had a package policy. Hard to believe that a community that large with that many improvements had a package policy. Well, the agent had never come out to the property, didn't know that the amount of insured for property damage was not sufficient. And when I called them and I said, can you please send me a copy of the endorsement for the D&O, they said, well, there is no D&O because it's a developer-controlled property, and the package policy doesn't have D&O for developer-controlled property. I had to point out to the agent that it said in the policy that they were being charged $80-some-odd for a D&O endorsement. And they finally said, well, that was a mistake. We should have never done that. They wanted to refund the $86 as opposed to provide the coverage. Mm-hmm. And so when I looked at that, that's when I started my ABC classification, if you will. The C classification is the package policy for everything. And it's basically a piece of paper. Sometimes it looks nice, sometimes it doesn't. It says directors and officers insurance, but provides little, if any, coverage. You have the top tier, the A policies, which provide the coverage for the things we've mentioned. Then you have that lower tier, just a little bit lower, a little bit less expensive, which still may be a reputable company, standalone policy, but does not include all of the things that someone would recommend that coverage be for a community association. One of the things which I consider mandatory coverage is something is lacking. And I guess the only reason you go to there is when you don't have enough money to pay the extra $300, which to me is pretty amazing. But I really think they get there. I think they get to the second tier, the B tier, because the manager's thinking they're doing the association a favor by saying, hey, guess what? I saved you X dollars, $300, $400 on this year's D&O renewal. And no one on the HOA board says, what did we have to give up?
Yeah. And the worst part about that $300 they're giving up is coverage for that management company. They believe because the management company is listed under the GL, it's automatically listed under the D&O. And that $300 savings, the first thing he misses is the fact that he's not insured.
Right, right. So they're out of coverage. Or if they're in coverage, even if they're in coverage, and it doesn't include non-monetary damages, and the lawsuit comes in for a declaratory judgment to declare that what the association and management team are doing are incorrect. Then they have an indemnity to the association, and they're going to have to go back to explain to the association, you have to pay for our defense because we didn't buy the right insurance for you. Mm-hmm. Yeah. It's kind of scary.
Mm-hmm. Mm-hmm. So education is very important for people to know what they're buying and what they're not buying too at the same time.
Correct.
Mm-hmm.
And I think the brokers really need to start the education process to the customer. And the customer, candidly, although it's the association, it really isn't. They're getting to the customer through the management company. And they need to explain to the management company that when insurance is purchased for the association that also insures them, they need to buy the broadest form policy that covers the most humanly possible, because that extra few hundred or $1,000 spread over the course of a year is nominal compared to what the actual out-of-pocket cost would be for an uncovered event.
Mm-hmm.
And that's such a big problem because a lot of agents out there are setting themselves up to say, guess what, I can save you $400 on your D&O. Why are you spending $1,000 for D&O when I can get you one for $450?
Right.
That's the problem too. Yeah.
Right. And if I'm the management company, I want to say to that broker, that's a great thing. Tell me what is not covered that used to be covered. And if they write back that says, hey, it's just as good a coverage, there's no difference between the policies, then you have an E&O policy for the D&O portion that's not covered.
Exactly.
That's it. Maybe not a popular conversation for today, but I really think that promotion of a less expensive inferior product is a bad idea. Less expensive equal product, I have no problem with that at all.
Okay.
Mm-hmm.
But equal
Absolutely.
products have to be equal in coverage, in claims handling, and in panel counsel assignments.
Mm-hmm.
Not just cost. Not just cost.
Mm-hmm. Absolutely. And speaking of claims, what is the number one claim where coverage was a major issue? Where have you seen that?
I think it's the property damage claim. Kevin, maybe you've seen something different, but really I think that's the only one that's out there that's the number one, if you call it.
And I think the number two is, like we said before, if you move your D&O coverage and there's something out there, there's something that they have knowledge of, and you moved it, and all of a sudden now that claim comes in, and you go back to the board and said, wait a minute, didn't you have this? Yeah, but that guy complains all the time. That's the problem.
Well, the best thing to do is the swan song letter to your carrier if you're going to change carriers, and list out every potential possible and attach every email and everything else that came along with it, so that at least you have them on file.
Mm-hmm.
Mm-hmm. Mm-hmm.
Now, you have to recommend that to your to some of your clients?
HOA clients are unique. They call you when they think they need you, not when they really need you.
Mm-hmm.
And so if asked, we would say to them, why are you switching?
Mm-hmm.
And if they say to save $300, we would have a stern talk with them. We wouldn't even bill them for that conversation because we believe that's public service.
Mm-hmm.
If they're changing because of a non-renewal, well, that's interesting, yeah. Or if they're changing because the premium got up to the heavens and somebody else will give them a similar coverage for less, then we go ahead and we try to explain it to them. But at the same time, we say, now before the end date, before you transfer over to the next company, somebody has to sit down with everybody and go, who is so upset with us? Who did we receive a threat from? Who did we receive this from? To where it could be construed to be a claim. Mm-hmm. And put together a massive report to the exiting carrier that here are things that we're now aware of. Now, they haven't matured into a what lawyers call as a real claim, but they've probably matured to the point that you would consider it a claim for your bond.
You hit the nail on the head, because whenever we tell somebody, recommend they have to move from one D&O carrier to the other, do you have any fact or circumstances that may give rise to a claim? Yes or no? If you have none, then you're in great shape. If you have any, write it down, put your current carrier on notice so you are protected. Right. And nobody does that, though. I mean, it doesn't happen, and that's why you run into those situations. It's it's hard to move D&O, but when you move it, you got to make sure you're protected, and there's no better way of protecting them unless you submit all those letters, all those emails, because something out there, every association out there had that mental patient in there that make it rise to a claim, right?
There's a legal requirement there be at least one wacko person in every community, no matter how small. And when they start getting big, I figure it's about 376 homes or units to each person who could cause you a trouble. So that's statistical numbers based upon my 35 years of doing this. And no, truly though, what happens is we get involved when the declination letter comes from the new carrier. And so we don't ever get in there to tell them to do this. The broker is the first person that reaches with them that's changing them. So if a new letter gets signed, representation letter, then that new broker really owes a duty to that policyholder to tell them that they really, really need to be doing this. And it's not easy because you know how it works. The community manager of today wasn't the community manager for 3 months ago, and they're not going to go back through all those records. And my God, they now work for a competitor. They don't want to talk to us anymore. And we just had board elections, and the 3 old board members just all got thrown out. We have 3 brand new guys, and they don't want to go back and read all the minutes. So it's a difficult situation to find out every potential claim that's out there. But it really makes you say to yourself, do I really want to change carriers? And if I do I really want to do it now when I have insufficient knowledge of pending claims?
Excellent.
Excellent. Thank you. If you had to choose what a type of claim that scares you the most, could you choose one? Pick one that makes you the most nervous.
Sherry, you don't know me well enough. I fear no claim.
Of course, of course.
The claim that causes me the most concern is the claim against the board who has not read their documents, okay? Because preparing someone for their deposition and finding out the first time they read their bylaws and declaration was last night is really, really difficult. Because then we have to have a conversation with them that explains that we probably will not be able to get them extracted from lawsuit based upon a volunteer immunity standard of care statute, which is what we try to do whenever anyone is individually claimed inside of a suit. So these things generally happen, in my mind, from the non-professionally managed communities. These are generally on the smaller side. The volunteers all have to get together and they, quote, do the best they can because they're only volunteers. That argument is a horrible argument at the courthouse. That argument worked well in the 70s and early 80s. But in the teens that we're in right now, the community association's respect level from the court is pretty low to start with. And then the judge just looked right at you and goes, I don't care if you're only a volunteer. You're messing with this people's house. You ought to do better. And so that scares the living heck out of me because I know that someone's going to get punished as a result of their failure to do their job. So that standard breach of fiduciary duty type claim comes back and bites them because even though they don't have a fiduciary duty in most of the single family settings, they do in a lot of the condo settings. And to get to standard of care, even of ordinary care, you have to exercise good faith. You cannot exercise good faith if you don't know how to do your job because you haven't read your governing documents. Period.
And Kevin, that goes to the point that we talk about quite a bit about the board members being volunteers and they don't really look at it as a business, right? We talk about that quite a bit.
And that's the thing that scares us too. It's, you know, we know the larger associations and mixed-use associations with lots of employees, that's something we have to look at very carefully. But the reality is, Mark is right. You're looking at these boards of directors who have a small association or large association without independent management, and they get together and try to make decisions about the roofs, about the pool, about the pets, enforcing the documents. And in reality, they come in and talk about what was on last night, what movie you want to see, what books you're reading, and they treat it as a hobby, not as a business. So those are things that bother us because those are where you're looking at a larger loss and a harder loss to really, because you're talking about discrimination, you're talking about a lot of different issues there that we don't see, even though the large-scale associations are probably bigger issues for us and have more exposure. Those smaller ones that are not really lack the knowledge are probably a bigger issue. I agree with you, Mark.
And now another hot topic that's in the news is cyber. And we're seeing lots of cyber claims. We just saw a hack that occurred in Florida. A hospital in London, I think, was hacked a few weeks ago. So there's ransomware and cyber attacks. Can you guys talk about cyber claims a little bit and D&O coverage as well?
You know, I don't know of any association that has gotten hacked and then you use the big word yet. I have had management companies who have been hacked to where the association's funds have been lost, and the association management companies have had to come out of pocket to replace funds that were lost. but it's just a matter of time. There's a lot of confidential information, according to the law is confidential information anyway, that is available on association product software and management company product software. And at the end of the day, if someone does get damaged as a result of it, there's going to be somebody who has to pay, and there has to be either insurance or a conscious decision to not have insurance for that type of a claim. And on top of that, even if there are no damages as a result of a breach, the mere fact that there was a breach is going to mandate that there be some monitoring and reporting. And that wasn't probably in the annual budget either when they forgot to raise the assessment for the last 3 years. So these are all possible issues that are going to come down the pike. Now, just like all DNOs are not created equal, it's my understanding that all cybers are not created equal. I've only read 2 or 3 policies, so I haven't read a lot of policies yet, but I can see that different things are covered in different policies as well, and the prices are all over the board.
Yeah, the problem with the coverages is that it's evolving. We put a policy together with 4 insuring agreements, and we left out e-extortion because we never thought that would be exposure. Well, today, the big exposure out there is e-extortion coverage. Social engineering, something we never heard the word before. Now, everybody's been hit with social engineering claims. So it's evolving. Our biggest fear right now on the cyber side is that management company who handles 200 associations and average 200 units per association, and somebody hacks that system and ends up with all the social security numbers and addresses and names of all those individuals. That's my biggest concern, because the management company will not have an E&O. He won't have a cyber policy. He won't have D&O. He's out of business, and you have all those 200 associations with 200 individual unit owners. No, well, we have 200 people, 200 individual units, but they have 4 people who live in those places. The numbers are unbelievable. Yep. That's why it's something that will be a bigger deal in the future than it is right now.
Right. If you look back, though, all of these are evolution of policy as a result of society. And back when you first started doing this, Kevin, what was the average cost for a $1 million D&O policy?
About $450, $500.
Exactly. And that was because there really weren't a lot of claims, and the average claim could have been resolved for $4,000 to $5,000. Nowadays, the policy has not gone up proportionate to the resulting potential damages, and the average claim defense costs are probably in the $25,000 range. Okay? Yeah. And I look at this and I go, okay, well, that $400 policy is probably now $2,500.
We wish it was. You're talking about $1,000 policy, okay?
Well, come on now. Really, $1 million policy, $1,000. People should be buying a lot of this stuff. That's pretty darn cheap. That's cheaper than a personal umbrella policy is.
Absolutely.
So I didn't realize it was still that inexpensive. Why would you shop a policy like that to save $100 or $200? Why would you do that?
Yeah. My thoughts exactly.
Maybe if there was a better product, but I don't know that they are. I think you guys are a top tier product, and there's probably just a couple of others. So it's all volume, right?
It's all volume. Mark, we have about 30,000 D&O policies right now throughout the country. Wow. And you're right. For $1,000 a piece, the average, when a claim comes in, you're talking about $20,000 claim, just to go out and defend it, just to prove that the board had the right to pass the rule or to collect something or to do something. And that's what we're looking at day in and day out. And the problem is that we end up seeing more people complain because I'm not paying $1,000 where somebody else is paying $350.
But what are they getting that's different?
Yeah.
That's the big question. I don't
think the top tier policies are that far apart. I think we're comparing a top tier policy to a C tier policy, though.
Exactly. Yeah.
So apples and bananas again.
Are there any D&O coverage and claim trends that you both are seeing?
Okay. The trends that I'm seeing lately are relating to the short-term rental deal that's going around. I mean, it's been around for quite a while, but it's hit some of our communities that are, I call them resort-style communities. They're master plan communities. But imagine if you need a little holiday for your kids, and you can get into a community that has a golf course, a swimming pool, and tennis courts, and a lake, maybe even an airplane runway, and you can rent my house, my 4,000 square foot house, for $350 a night. Now, you can't do that in a hotel because you need about 6 rooms to be able to make that happen, and you're not going to have all those amenities. And so the communities are now having to deal with people who are trying to make supplemental income that way. And another issue that's come along are what's called these next generation houses. And I don't know if you've seen these or not, but some people are modifying their homes to allow them to lease out a portion of their home, either short-term or long-term, so that they can afford to live in their neighborhoods. And they weren't started this way. They were started to where your parents and you, with your children, can live in a house under one roof, but had separate commons and some joint commons. There's a couple of national home builders that are making these under a next generation type product name. And so these are like things that are new, and whenever something is new, there's a problem, okay? Homeowners are going to say, well, I just don't want that here. So the VRBO, the Airbnb, is taking hold on all these. They're marketing out, hey, if you're going away for the summer, why not lease out your house for the 4 to 6 weeks? Or if you're just going away for 2 weeks, why don't you lease it out for 10 days? You can make yourself $300 a day, help pay for your own vacation while you're away. And if you think people don't do this, I was told that one of my shareholders at my firm did this for his own home. Because there was a big music festival in town, and he was making a lot of money per day. I mean, it takes a special arrangement to let somebody go through your own sock drawer. I wouldn't want it in my house, okay? But there are a lot of people who are using this as an opportunity to have supplemental income and maintain a lifestyle. So that's a trend. Associations don't like it as a whole because we don't like renters to start with. Right. Short-term renters we really don't like because they don't take care of our property. So that's the first one. The second one that I think that's out there is the smoking trend and the anti-smoking trend. I think that's something that's causing some consternation. We've had some lawsuits, we've had some claims over that, where associations have instituted policies to not allow smoking, and it's a gradual erosion of that right, if it is a right, and that's common areas, limited common areas, and inside the unit itself. There are places where if you want to smoke, you got to go out in your car with the windows up, you know, and so you've agreed to be bound by reasonable rules and regulations, and these have been found to be reasonable rules and regulations. So those are two of the things. The third, dealing with the smoking as well, is the states that have medical marijuana going on. Okay, we've now said that there's not going to be any smoking, but I have a prescription from a doctor that says that this marijuana that I shall smoke will be medically necessary for me. So now potentially we have fair housing claim on top of a smoking claim, on top of the allergy from the neighbor next door, on top of the fact that you can't get federal protection under fair housing because it's a violation of federal law to have the marijuana to start with. So now we have to go find a state law which allows for the accommodation, and a lot of states do have fair housing statutes. And so it's just a real complicated jumble. So maybe we'll talk about that in the future.
You know, one thing I would add to what you're saying, Mark, is especially with the Airbnb and everything, is the ADA requirements now all of a sudden. You know, you look at community associations, they fall in the Fair Housing Act because there's no commercial, but now all of a sudden you're renting your individual unit out like that. Now all of a sudden you have ADA issues.
Yeah, and I'm wondering who the ADA claim would be against. You know it would go against the association because you always look for somebody with a pocket. But the association should be able to look back and say, we didn't lease that unit. In fact, we don't sanction the leasing of that unit. It's the individual unit owner that should be taking care of that. But under ADA, a lot of these community associations have put their property into ADA that weren't before by making them open to the public, by letting the public generally reserve area, or we have pools that have excess capacity. So we're now selling memberships for $1,000 per summer. Your family, even though you don't live here, can become part of our community pool. Those also expose you to ADA type of issues. The other thing we have is in Texas, we have a sales tax exemption statute. If you can come under it, the community association can become exempt from sales tax. Well, one of the things you have to represent is that your common elements are open to the public. And so they check off that box thinking they're going to save all this money on taxes. Hell, after all, the landscape contract alone is $500,000. Add 8.25% tax on top of that you're saving every year. You can check off that box with an unguilty conscience. Next thing you know, one of your neighborhood people from next door want to come in and go, well, you've represented in a state filing that you're open to the public. Here I am. Another APA claim.
Yeah.
So these are things, you know, you look into the crystal ball, we pick 10, 2 of them might come true.
It can go in a lot of different directions, that's for sure. Absolutely. If you had to pick a type of association that gives you your biggest headache, what type would you pick?
Well, that would be that small association, the unprepared, unprofessionally managed. Those are really the only ones that give me a whole lot of concern because they're harder to defend. They're also harder to represent on the front side. You know, I will say that it'd be interesting to see, Kevin, if you looked at the 1,500, 1,600 associations that I represent, how many of them have had claims over the past 20 years? Because what we have tried is our own internal claims avoidance techniques. The ones that we usually get to defend are not our clients. And I think that's because we don't represent very many, if any, of the communities that fall into that category of unprofessionally small managed associations. A lot of self-managed, but they're professionally self-managed. Yeah.
And I think that's important, Mark, because from our point of view, we always thought that the large associations that maybe have equestrian trails, that has tennis courts, 30, 40 employees, where the exposure was at. But the reality is that they are professionally managed. They usually have people there who have that knowledge, experience to be able to manage large associations. And the reality is it ends up being the smaller associations that really have no idea, no knowledge. They don't have that sophistication that's needed to run an association.
Yeah, I'll give you a story about a claim that was turned over to us yesterday, and it was a claim dealing with a real estate title-related issue. So it was kind of interesting. I kept it on my own desk. And when I had the conflict check prepared, I found out that we actually represented this association. So I called up the shareholder who's handling it, and I said, hey, I heard your association, ABC, got sued. He said, yeah, but I resolved it last night because I knew that we weren't going to be able to do anything. We were going to spend a whole lot of money. So by the time the claim was turned in, my team had already gotten the judgment taken, which had no dollars against the association, because they knew enough to contact the attorneys and get some sound advice on the front side before it turned into an extravaganza. So many of these are about the attorney's fee. We can't settle the case because the other side's legal fees have grown astronomically disproportionate to the claim.
Wow. Good point. Very good.
Great. If you had to choose the major differences between our policy, Kevin Davis's insurance policy, D&O policy, and our competition, could you talk about how that's impacted claims? I know we talked earlier about, you know, high-level policies, A, B, and C policies. So how would that, obviously exclusions would play into it. I mean, that's the main.
I'll tell you this. We had a claim assigned to us from B-level carrier. Okay. And it was a breach of contract claim by a landscape contractor. And after we started handling the claim, we were told that it would not be covered any longer because it was a breach of contract claim. And so that was an exclusion under their policy. They shouldn't have assigned it in the first place. The association engaged my firm to continue to defend it and paid a six-figure attorney's fee. And they had just switched from a top-tier company to a mid-tier company.
Wow. To save a few $100s.
Yeah. I think they might have saved $3,500 because it was a very large association.
Oh, okay.
But
still,
what kind of savings you can make up?
There are different tiers of policy. The bulk of all the people out there had that smaller C that's in the package. We have the A. But I would say one thing we haven't talked about was all the A's are pretty similar. The claims department makes a difference. From our point of view, we put together a claims department that specializes in community associations. That's what they do. They handle community associations all over the country, and they assign lawyers like Mark here who specialize in community associations to get these things resolved very, very quickly because they're emotional and they can go on for a very, very long time if somebody gets in there and say, guess what, let's settle it. Right. Claims people are very important.
And some of the other top tier companies have combined claims department, which may or may not be a problem depending upon the complexity. If it's a complex claim, they might not be able to truly understand the nuance. And the other is they have capture counsel. Capture counsel is actually employees of the insurance company, and these are folks that handle all level of claims. They're going to handle personal injury claims, they're going to handle slip and falls, they're going to handle workers' comp, and I can say that we've taken over claims and became panel counsel for association insurance when they paid out more than the limits required under the law because the attorneys didn't know what the law was.
Mm-hmm. Mm-hmm.
Okay? So it's pretty easy to say, you paid $1 million, there was a $400,000 cap, you should have saved $600,000. Well, yeah, your hourly rate's a little bit more than the other guy, but it's one of those same things. You don't make that up. You just have to have the institutional knowledge to be able to defend it properly. And putting that into perspective is kind of like saving $116 on a policy.
Mm-hmm, mm-hmm, absolutely. Do you, Mark and Kevin, do you have any difficulty explaining coverage to people, or what do you find the challenges in explaining coverage to insureds?
We're very rarely asked until it's way too late. Those that ask before it's too late, I don't have any problem explaining it because I explain to them it's either their money that's going to pay a claim or the insurance companies. And if they're not being paid because they're a board member or they're being paid so outrageously because they're a manager, either one wants to protect their own personal assets. And so I've never had a problem explaining to them why they want the best that they can possibly afford. But don't get the opportunity to get to that table very often.
Mm-hmm. Yeah, and that's the problem. It's a matter of sitting down with somebody who can make a decision and telling them that don't worry about saving the $300, buy something that will protect you in the long run. And that's difficult because it's always somebody who comes behind you and say, guess what, it's not that big of a deal. $300 is a lot of money to save. We are heroes, don't worry about them. And guess what, it's always easy to listen to the person who's saving you money.
True, very true.
Mm-hmm. Absolutely. There's an old expression, penny wise and pound foolish.
Yeah.
You know, so you don't want to save a penny in the beginning and then paying a lot more in the end. But
exactly.
Mm-hmm, absolutely. Great. Well, thank you, Mark and Kevin, for a great webinar. And
thank you.
Thank you, everybody, for joining us today. And again, I just wanted to mention that I put all of our webinars on our website at kdisonline.com. You can just click on the webinar link and listen to today's webinar and our past webinars. And then we have another one coming up in June, which is June 15th. And that topic is the top 5 reasons your association needs an umbrella. So thanks, everybody, and have a great afternoon.
Thanks a lot, Mark.
Thank you. Take care.
We'll see you in September.
Absolutely. Bye, y'all.
Bye.